Alex here with part 62 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0, if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. The gap of time between me filing the reply and receiving an order from the court is not one that is very memorable to me. I was probably hopeful that the court was going to take some kind of action, and that didn't happen. But of course, I don't know what else I can really say about how I felt aside from dismayed. It certainly didn't stop me, because I do know that I filed an appeal to this order. But at the same time, it's one of those situations where I would have felt that this is something that's going to go ahead and keep going, continue. It's going to keep happening because my ex is going to continue to get signals from the court that what she's doing is okay. I think part of the problem here is that the court does not know how to deal with mental health issues, with parents who have mental health issues. And so the court probably thinks that we are both fit parents and that we are just fighting with each other. I don't think that the court understands that she has a sort of existential attachment to the conflict in this case, to the ongoing struggle between the two of us. And for those reasons, it's not that she won't stop it, it's that she can't stop. And so she's not going to respond to anything but force. But this is just me reflecting on the court's lack of understanding as to how to deal with a case like this. I think that this is an order that's going to speak for itself, so we may as well go ahead and take a look at what the judge has filed. Here we have the court's order denying motion and urging participation in parenting class. It's interesting that he chooses the word urging, because an urge is not an order. First paragraph, the court reviews or indicates that it reviewed my motion and her opposition and my reply. The next paragraph, the court summarizes the fact that we share a common child. Paragraph after that, the court asserts or points out that I allege that my ex subverts my right as a parent and joint custodian. I asked the court to award me sole decision-making in relation to education and to award her sole decision-making in relation to healthcare. And my motion indicates that I do not request a hearing. Her opposition alleges that I am inappropriately litigious. Lovely, because how is that relevant? Also, I've mentioned this before on a number of occasions, but litigiousness and an intent to harass are two different things. The Supreme Court states this over and over again, and judges fail to understand what that means, and attorneys either same issue or they're just playing dumb. One of the two is going on. You can't argue that somebody is litigious and therefore they should lose. You have to show how they are trying to harass you through the litigiousness. That's a crucial component to that allegation. Anyway, residentially unstable. Okay, so he's pointing out that they're mentioning that I move around a lot. She's arguing that the division of legal custody urged by me is not in his best interests, which is completely wrong. And in fact, this refusal by the court to delegate our parental duties actually leads to the total and utter deprivation of her legal custody rights. So she doesn't realize this, but she's actually fighting for her own demise at this point. She's trying to win something small now, which sets her up to lose everything later on. And it's not just her failure to understand that, it's her attorney's failure to understand it, and it's also the judge's failure. The allegations made by my motion are insufficient to warrant a change of legal custody. My motion is denied, and no award of attorney fees is going to be made. So what he is saying here is that even if everything I am alleging is true, those allegations are not enough in and of themselves to modify changing legal custody. I can't remember now what all of my allegations were. Maybe I'll give him the benefit of the doubt at this point in time as I'm doing this video, and when I go into the appeal, I'm going to scrutinize this a whole lot more, and I'll give a more detailed response on whether I agree with him now in hindsight or whether I don't. Usually, I will have a good idea as to whether or not I think he's just BSing or if he's actually doing what he's supposed to as a judge. And I'm going to go ahead and take a closer look at this, especially since we're filing an appeal, or I'm filing an appeal on this anyway. And I'll take a careful look at that opening brief and decide whether or not I can agree with that or not. It's tough to say because this is back in 2010. We're now in 2020, so 10 years ago. It's a very fuzzy recollection. I could stop this and take a look at it, but since I'm doing the appeal anyway, we have an opportunity coming up where I can take a closer look at that. The court urges both of us to take the 4-evening course, Cooperative Parenting After Divorce. The course is a value to parents in conflict, even if they have not been married. Okay, this is ridiculous. This is the kind of stuff that works for two people who are mentally fit. You can't subject a mentally unwell person to some kind of course like this and expect them to magically understand what's going on. And in this particular situation, I think it speaks for itself that I attended the course and she refused to. So, okay, it's just frustrating to see them try and do this type of stuff to try and sort of get us to become better parents when it's not really their job to do that. They're there to dispense justice. They're there to apply the facts or apply the law to the facts of the case and render a decision. And they sometimes wander into this area of parenting manager. And this is just something that doesn't work in high conflict child custody cases. This judge isn't going to be seeing us every other day and giving us feedback. He's going to see us once every 6 months if we're lucky. And it's just an impossible role that he's trying to take on. He's trying to like give us the education that we need to co-parent when it's not his role as a judge to do that. And it's a waste of his time, and it's just going to end up doing all of the things that I mentioned previously. It's just going to end up resulting in the termination of my ex's parental rights. What she needed was firm decision-making from the court. She didn't need this kind of stuff. Certificate of mailing, which just indicates that he mailed the document to my old address. The court has disposed of one motion. That's the motion that I filed seeking for a delegation of parental rights. It did so by denying that motion. Going into the aftermath, I didn't file anything, so I incurred $0 in costs. My ex didn't file anything either, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably spent very little time reviewing this, maybe 10 minutes, 5 minutes max. But she would have had to communicate with my ex over the phone to let her know what the order meant, probably also give her a little bit more information on that parenting class. So probably 15 minutes went into this. That's going to come to a total of $62.50 in attorney fees for my ex. And as with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.